Hello, this is Joshua Stein. I want to speak with you about a few actual FDCPA court cases, so you realize that the damages that the courts award for violations can be significant. So please follow our instructions about tracking and documenting communications from debt collectors so your Resolve legal plan attorneys can prosecute violations on your behalf. I will discuss 3 cases that are slightly different, but all of which resulted in significant damages awarded to the plaintiff. Medley v. Dish is a violation of the Florida Consumer Protection Statute, which prohibits debt collectors from contacting a consumer who they know to be represented by counsel. The Johnson case is a violation of the FDCPA as well as the Washington Consumer Protection Act, involving attempts to collect amounts not owed, credit reporting of an inflated balance, and false and misleading statements and threats. And the Hanrahan case was about a misleading collection letter and improper negative credit reporting threats. In Medley v. Dish Network, which was tried before a jury, the plaintiff, Linda Medley, was awarded $1,000 in statutory damages, $8,750 in actual damages for emotional distress, and $225,000 in punitive damages. Medley signed up for the Dish Network's satellite TV service, but later became unable to pay for the subscription. Dish offered a pause program that allowed her to suspend service for up to 9 months at a cost of $5 per month, which she accepted. Ultimately, she filed for Chapter 7 bankruptcy protection, listed Dish Network as an unsecured creditor, and obtained a discharge of her debt. Medley's lawyer sent 2 faxes to Dish Networks providing notice that she was represented by counsel. After receiving notice of representation, the defendant, Dish Networks, sent 5 billing notifications to the plaintiff and made 6 telephone calls attempting to collect on the $5 monthly payment. The plaintiff filed suit against Dish, alleging violation of the Florida Consumer Collection Practices Act, which makes it unlawful for a debt collector to communicate with a debtor if the debt collector knows that the debtor is represented by an attorney. The court found that emotional distress suffered by plaintiff, confusion, worry over her credit, and heart racing, was a form of physical harm that could support punitive damages. The court also found that the evidence supported a finding of indifference to or reckless disregard of the health and safety of others. Specifically, Dish Network's bill collectors repeatedly contacted Medley despite its knowledge that she was represented by counsel and that she had filed for bankruptcy. In Johnson v. Columbia Debt Recovery, a Washington District Court awarded the plaintiffs, husband and wife, $30,000 each in emotional distress damages under the FDCPA and $2,000 in statutory damages. The court granted the plaintiff's motion for summary judgment, finding that the defendant, Columbia Debt Recovery's actions had violated the FDCPA, in addition to the Washington Consumer Protection Act. These actions included attempts to collect amounts not owed in 3 separate phone calls with one of the plaintiffs, 1 letter that was sent to both plaintiffs, and repeated and ongoing credit reporting of an inflated balance. The defendant allegedly made false and misleading statements, including that a judgment had been entered for the alleged debt, claiming that plaintiffs' wages would be garnished, that plaintiffs had been evicted, and that the various charges and fees they demanded were legitimate. The court emphasized that, even without expert testimony, the Johnsons' credible testimony regarding their stress, anxiety, feelings of helplessness and hopelessness, and other forms of general emotional distress in a particularly vulnerable time for both husband and wife, as they were experiencing the joy and challenges of raising a new baby in response to a debt collector's numerous false and misleading statements in an attempt to collect a debt, was sufficient to establish emotional distress damages. Leah Hanrahan incurred a medical bill that was sent to defendant's statewide collection. In January 2018, statewide sent the plaintiff a collection letter which she contends was misleading and improperly threatened negative credit reporting. The plaintiff filed suit in the District Court for the Northern District of California, asserting claims for violation of the FDCPA and the Rosenthal Fair Debt Collection Practices Act in California. The District Court granted summary judgment in favor of the plaintiff on the issues of liability under the FDCPA and Rosenthal Act. Statewide then made an offer of judgment of $7,500 exclusive of attorney's fees, which was accepted by the plaintiff. Thank you for enrolling in the Resolve legal plan, and we appreciate the trust you have placed in us. Our goal is to help you resolve your debts, restore your finances, and rebuild your credit. We will be asking you to watch short videos like this one throughout your program, which we hope you will find helpful.